But that said, the petitioner has the burden of proof, and the burden in these cases by preponderance of the evidence, which in layman's terms mean more likely than not. 51% I believe, 49 I don't. Well, that's good enough. You met the burden of preponderance of the evidence. If you're looking at like a scale, if it's tilted slightly in favor.
It's just enough.
Correct.
Yeah.
So whereas in the criminal world, beyond a reasonable doubt, that's a very high standard. It's not that in these cases. So you start with that basic premise that a petitioner has the burden of proof. And how we challenge these at a hearing is almost always twofold. It's credibility and the veracity. You know, we are challenging that this petitioner is not credible, and in many cases, these things turn on text messages. It turns on emails, things like that, where we can refute their testimony, show them that they're not credible, and furthermore, show that the statements that they're alleging or they're saying that our client did are not truthful. And you'll see a lot of this in this arena. Sadly, this area of law, it doesn't take much in terms of going. You can walk into the courthouse. I always joke about this and tell folks that I could walk into the courthouse after we are done with this. I can walk in there and say, my wife hit me on the head with a frying pan last night at dinner, and guess what? She will be served with an order of protection. She'll be ordered to leave the house, because she'll have a foot restriction, right?
Sure.
And that'll be temporary, a temporary order until a hearing is set, which is usually 2 to 3 weeks down the road. And she's out of the house, just like that. And I could completely fabricate, and these are, in many of these cases, these are fabricated allegations because for whatever reason, a boyfriend-girlfriend dispute, cheating, financial stuff, neighbors that are feuding. You see that commonly.
Well, it's fueled by emotion.
It is. And they do it in the heat of in the moment, typically. A lot of times cops get called on domestic cases, and there's not enough evidence to make an arrest. And what do cops will routinely tell people, go file an order of protection. It kind of punts it off of their radar.
Sure.
Sends it to the court. They're not involved. Hey, we don't have enough here to arrest. Go file an order of protection. And it's kind of wiping their hands clean of it, right?
Mm-hmm.
They put it in the court, let a judge make a decision. They're not involved in this. And so that's how these things get triggered in many cases. A lot of times when folks learn of this process, it's ripe to be abused. Hey, I just can go down to the courthouse or the police station and fill out this form.
It's terrifying.
Like I said, it is.
Yeah.
I always say to people, I say, I could literally use that analogy all the time and say, I can walk in there, say, my wife did this last night at dinner, hit me on the head. Here you go, ma'am. She's served. She's out of the house until that hearing date. It's scary. But back to the initial question, it was we challenge the credibility and we challenge the truthfulness of their statements.